Parliamentary sovereignty is a concept in the constitutional law of some parliamentary democracies. It holds that the legislative body has absolute sovereignty, and is supreme over all other government institutions, including executive or judicial bodies. It also holds that the legislative body may change or repeal any previous legislation, and so it is not bound by written law or by precedent. Parliamentary sovereignty may be contrasted with separation of powers, which limits the legislature's scope often to general lawmaking, and judicial review, where laws passed by the legislature may be declared invalid in certain circumstances. Many states have sovereign legislatures, including the United Kingdom, Finland, the Netherlands, New Zealand, Sweden, Barbados, Jamaica, Papua New Guinea and the Solomon Islands. United Kingdom. History. Parliament means, in the mouth of a lawyer, the King, the House of Lords, and the House of Commons. These three bodies acting together may be aptly described as the King in Parliament, and constitute Parliament. The principle of parliamentary sovereignty means neither more nor less than this, namely that Parliament thus defined has, under the English Constitution, the right to make or unmake any law whatever, and, further, that no person or body is recognised by the law of England as having a right to override or set aside the legislation of Parliament. During the 17th century in England, a notion developed that Parliament shared in sovereignty with the King, based on an entirely erroneous notion of the history of Parliament. It was not until the changing of the Coronation Oath in the Coronation Oath Act 1688 as part of the Glorious Revolution that Parliament was recognised as part of the constitutional structure, with laws being considered to emanate from Parliament and not just the King. The Bill of Rights was passed the following year, which asserted certain rights of Parliament and limited the powers of the monarch. Furthermore, in 1698 Parliament created the Civil List, a financial arrangement that left the monarch reliant on Parliament for income. After 1689, English parliamentary supremacy became evident in the relation of the English Parliament to those of Scotland and Ireland. The Act of Settlement 1700 made a presumption upon Scotland. The Scots retaliated with the Act of Security 1704, which was countered by the Alien Act 1705. The issue was settled by the union of the Parliaments of England and Scotland in 1707, which created a new British Parliament, though in essence it was just an extension of the English Parliament. It is arguable whether the concept of parliamentary supremacy arose from the Acts of Union 1707 or was a doctrine that evolved thereafter. The autonomy of the Parliament of Ireland also came under attack, and the Declaratory Act 1720 made the Irish Parliament a dependency. The so-called Constitution of 1782 removed British parliamentary supremacy over Ireland for a short period, but then the Irish Parliament was merged with Britain's in the Acts of Union 1800. The doctrine of parliamentary supremacy may be summarized in 3 points. Parliament can make laws concerning anything. No parliament can bind a future parliament. A valid act of parliament cannot be questioned by the court. Parliament is the supreme lawmaker. Some scholars and judges have questioned the traditional view that Parliament cannot bind itself, arguing that it can impose procedural restrictions on itself, since the legislature must be constituted and regulated by legal rules. The notion of parliamentary sovereignty began to be challenged with the Parliament Act 1911, which changed the nature of what was meant by Parliament, as Dicey regretfully noted in the introduction to the 8th edition of his Introduction to the Study of the Law of the Constitution, but that while the reality was now cabinet and political party were supreme, in law Parliament was still sovereign, albeit that the share of sovereignty of the Commons had increased. European law does not recognize the British concept of parliamentary supremacy. The UK courts currently recognise the supremacy of EU law on those subjects where the EU can legislate. However, this supremacy conceptually derives from the European Communities Act 1972 and its successors, which could in theory be repealed by a future parliament. No sovereign state has ever withdrawn from the European Union, but since the passage of the Treaty of Lisbon in 2009 there is now a defined process for doing so. Scotland. Some jurists have suggested that, following the Act of Union 1707, the principle of parliamentary sovereignty may not apply in Scotland. Although no Scottish court has yet openly questioned the validity of an Act of Parliament, certain judges have raised the possibility. Thus, in McCormack v. Lord Advocate, the Lord President stated that the principle of the unlimited sovereignty of Parliament is a distinctively English principle which has no counterpart in Scottish constitutional law, and that legislation contrary to the Act of Union would not necessarily be regarded as constitutionally valid. Also, in Gibson v. Lord Advocate, Lord Keith was circumspect about how Scottish courts would deal with an act which would substantially alter and negate the essential provisions of the 1707 Act, such as the abolition of the Court of Session of the Church of Scotland of the substitution of English law for Scots law. The establishment of the Scottish Parliament has meant that the area of parliamentary supremacy is redefined. For example, although nuclear power is not within its competence, the Scottish government successfully blocked the wishes of the UK government to establish new nuclear power stations in Scotland using control over planning applications, which is devolved. While it remains theoretically possible to dissolve the Scottish Parliament or legislate without its consent in relation to Scotland, in practice such a move would be politically difficult. England and UK generally, parliamentary supremacy is cited by contemporary American legal historians as the reason English law did not develop due process in the American sense. It is also argued to be integral to the way in which England's approach to rights and liberties evolved. The doctrine of parliamentary supremacy in English law was upheld in 2005 by Lord Bingham in the case of R v Attorney General. The bedrock of the British Constitution is the supremacy of the Crown in Parliament. However, there is a distinction to be made between legal sovereignty and political sovereignty. Parliament is not politically sovereign, which means that if Parliament passes unpopular or oppressive legislation, then it may not be applied in practice. For example, the various civil servants who administer laws within government departments may be relied upon to use any loopholes and vague language which exists in a bill to get around unwanted areas, and the judiciary is likely to purposefully interpret and create precedent for said laws in a similar manner. However, this does not necessarily mean that Parliament is not legally sovereign. It is argued that nonetheless Parliament can legally pass any legislation it wishes. This point is made clearly by Lord Reid in Madzimbamuto v Lardner Burke 1 AC 645. It is often said that it would be unconstitutional for the United Kingdom Parliament to do certain things, meaning that the moral, political and other reasons against doing them are so strong that most people would regard it as highly improper if Parliament did these things, but that it does not mean that it is beyond the power of Parliament to do such things. If Parliament chose to do any of them, the courts would not hold the Act of Parliament invalid. Recent developments. In recent years, some judges and scholars in Britain and New Zealand have questioned the traditional view that Parliament is sovereign. Others, however, have rejected these arguments. Various constitutional changes in the United Kingdom have influenced the renewed debate about parliamentary sovereignty. The devolution of power to devolved legislatures in Scotland, Wales and Northern Ireland. All three bodies can pass primary legislation within the areas that have been devolved to them, but the powers nevertheless all stem from the UK Parliament and can be withdrawn unilaterally. The Northern Ireland Assembly, in particular, has been suspended multiple times due to political deadlocks. The UK's membership of the European Economic Community, later the European Union, from 1973, the EU represents, as the European Court of Justice ruled in 1963 in the case Van Genden-Loos, a new legal order of international law for the benefit of which the states have limited the sovereign rights, albeit within limited fields. The UK became part of the legal order, though as UK membership of the EU has been brought about through Acts of Parliament, principally the European Communities Act 1972. Parliament could, as a matter of UK law, pass further legislation unilaterally withdrawing the UK from the Union, or selectively barring the application of European law within the UK. The European Union Act 2011 reaffirmed that sovereignty lay with the British Parliament, with Section 18 stating, "Directly applicable or directly effective EU law of the European Communities Act 1972 falls to be recognised and available in law in the United Kingdom only by virtue of that act, or where it is required to be recognised and available in law by virtue of any other act." The Act also requires that a referendum be held when more powers are transferred to the European Union, alternatively, as prescribed by the 2016 Brexit referendum, an act to withdraw from the European Union could be passed in parallel with the withdrawal procedure laid down in Article 50 of the Lisbon Treaty, whereby a member state would notify the European Council of its intention to secede from the Union, and a withdrawal agreement would be negotiated between the Union and the state. The treaties would cease to be applicable to that state from the date of the agreement, or, failing that, within 2 years of the notification. Following the case of Thoburn v Sunderland City Council, certain statutes are perceived to be protected as constitutional statutes. The case involved amendments to the Weights and Measures Act 1985 by the Weights and Measures Act 1985 Order 1994 pursuant to Directive 8181 EEC. This stated that imperial measurements could be displayed so long as the metric measurements were displayed in larger type beside them. Thoburn was convicted for only displaying imperial measurements. In his defense, he argued that allowing even limited use of imperial measurements was inconsistent with the European Directive and therefore in contravention of Section 2 of the European Communities Act 1972, and that the relevant section of the 1972 Act had therefore been implicitly repealed. However, the judgment by Lord Justice Laws held that certain statutes of constitutional importance, including Magna Carta and the European Communities Act 1972, could not be repealed by implied repeal. The case also introduces the concept of a hierarchy of acts, which is used in other European countries, to English constitutional law. However, if Parliament did make its intention to overrule any statute express, then any statute can be repealed, and so sovereignty is preserved. The enactment of the Human Rights Act 1998, which incorporates part of the European Convention on Human Rights into domestic law. The Act gives UK courts the power to issue a declaration of incompatibility where they believe that the terms of an Act of Parliament are in contravention of the rights guaranteed by the Human Rights Act. The effect of the declaration is not to annul the contravening act but to send a signal to Parliament, which may then choose to amend the offending provision. This does not endanger parliamentary sovereignty because Parliament may choose not to amend the offending provisions. As with the UK's membership of the European Union, the principle of parliamentary supremacy means that Parliament can at any time vote to repeal the Human Rights Act, and indeed the UK's ratification of the Convention itself. However, Parliament may theoretically withdraw from commitments it has made or repeal any of the constraints it has imposed on its ability to legislate. Australia. Under federal system, neither the states nor the federal parliament in Australia have true parliamentary sovereignty. The Commonwealth Parliament is created by the Constitution, and only has enumerated powers. Each state's legislative power is inherent but restrained by the federal constitution, state constitution, and Commonwealth powers. In this context, parliamentary supremacy has two meanings. One is that Parliament can make and unmake any law. Another meaning is that as long as Parliament has the power to make laws regarding a subject matter, the exercise of that power cannot be challenged or reviewed by judiciary. The second meaning is more consistent with the federal system and the practice of judicial review, as judiciary cannot review on the merits of the Parliament's exercise of power. Blackshield and Williams explain that, in Australia, the idea of parliamentary sovereignty must be understood in the context of the rigid limits and boundaries imposed by the federal constitution, and to some extent by the state constitutions as well. The Constitution confers the power to make laws in the Commonwealth Parliament, however, this limited to particular subjects. Section 128 of the Federal Constitution prescribes the mode to alter the Constitution, which further restricts the power of the Commonwealth Parliament. The Supremacy Clause gives Commonwealth laws precedent over state laws. The state law-making power is therefore constrained where the Commonwealth has concurrent law-making power. Furthermore, regarding the subject matters which Commonwealth has concurrent legislative power, Commonwealth Parliament can cover the field, which means the Commonwealth can by express words or implication exclude the operations of state laws. The Commonwealth Parliament has exclusive legislative power over the subject matters listed in sections 52 and 92 of the Constitution, which means that the states cannot make laws in these areas. Also under section 96 of the Constitution, the Commonwealth can use financial assistance to entice states to refrain from exercising their legislative powers, such as refraining from collecting income tax. Each state parliament power is subject to procedural limitation, which is the entrenchment of restrictive legislative procedure. Section 6 of the Australia Act states that laws concerning the Constitution, power or procedure of the Parliament are invalid unless passed in the manner and form prescribed by the legislation made by the Parliament. However, restriction of this kind is not inconsistent with parliamentary sovereignty. Belgium. Over the last 40 years or so, a change has been observed in Belgium in the relationships between the judiciary and Parliament. The dogma of absolute inviolability of the parliamentary assemblies has been breached. The parliamentary assemblies are now accountable not just to the electors but also to the courts. A first breach in the dogma of the inviolability of the assemblies was opened up by the Leski judgment of the 27th of May 1971, in which the Court of Cassation upheld the supremacy of the norm of self-executing international law. In 1980, Article 142 of the Constitution established a Court of Arbitration in Belgium, nowadays the Constitutional Court, charged with hearing actions for annulment of laws. It would hand down its first judgment on 5 April 1985. A second breach was opened in the dogma of inviolability of the assemblies in Belgium by the Constitutional Court, in its judgment No. 31/96 of 15 May 1996. The Council of State, the highest administrative court in Belgium, had till then always declared that it had no jurisdiction to hear annulment applications against the administrative acts by the Houses of Parliament. The Constitutional Court, declaring that the absence of any possibility to apply for the annulment of such acts was contrary to the constitutional principles of equality and non-discrimination, opened up a new avenue for judicial review of Parliament's acts. The laws of the 25th of May 1999 and of the 15th of May 2007, adopted in the wake of the court's judgment, extended the jurisdiction of the Supreme Administrative Court to the acts and rules of procedure of the legislative assemblies or their organs with regard to public procurement and personnel. Finally, concerning the decisions taken by the assemblies with regard to MPs or political groups, the civil courts have not hesitated to sanction them when subjective rights were at stake. MPs enjoy the protection of the subjective rights by the law courts. This principle applies both for rights deriving from the law in the broad sense and for rights which have a regulatory basis. Canada. Legislatures of Canadian provinces are sovereign within matters that are not delegated to the federal government. Provincial legislatures can make and modify their own codified constitutions by simple majority, as British Columbia did. Other provinces have uncodified constitutions like New Zealand and the United Kingdom. Similarly, the federal parliament is sovereign in all matters delegated to it, but most amendments to the federal constitution may only be made with the consent of both parliament and two-thirds of provinces containing 50% of the population, or in some cases, unanimous consent of the provinces. In addition, although a law can be challenged and struck down by a court when found to be in violation of certain sections of the Canadian Charter of Rights and Freedoms, parliamentary provincial legislatures may invoke the notwithstanding clause to allow the law to operate for up to 5 years, at which time it may either lapse or be renewed. Finland. According to the Constitution of Finland, sovereign power lies with the people, represented by the Parliament. As the highest organ of government, the Parliament holds supreme legislative power and can override a presidential veto and alter the Constitution. There is no constitutional court, and the Supreme Court does not have an explicit right to declare a law unconstitutional. By principle, the constitutionality of laws in Finland is verified by a simple vote in the Parliament. However, the Constitutional Law Committee of the Parliament reviews any doubtful bills and recommends changes, if needed. In practice, the Constitutional Law Committee fulfills the duties of a constitutional court. In addition to preview by the Constitutional Law Committee, all Finnish courts of law have the obligation to give precedence to the Constitution when there is an obvious conflict between the Constitution and a regular law. The power to alter and amend the Constitution is vested with the Parliament, requiring approval either by a two-thirds majority in a single Parliament if the proposed alteration is first declared to be urgent by a 5/6 majority of the same Parliament, or by a slower procedure of first passing the amendment by a simple majority in the then current Parliament and then passing the amendment by a two-thirds majority in the following Parliament that convenes after a general election. A Finnish peculiarity is that the Parliament can make exceptions to the Constitution in ordinary laws that are enacted in the same procedure as constitutional amendments. An example of such a law is the State of Preparedness Act, which gives the Council of State certain exceptional powers in cases of national emergency. As these powers, which correspond to U.S. executive orders, affect constitutional basic rights, the law was enacted in the same manner as a constitutional amendment. However, it can be repealed in the same manner as an ordinary law. Executive power is shared by the President of the Republic and the Cabinet. The latter must rely on the confidence of Parliament. for the independence of Finland in 1917 up to the constitutional reform of 1999, the president held considerable executive powers, and in particular was able to call a re-election of the parliament at will, in order to strengthen the role of the parliament as the highest organ of government. The constitutional reform constrained most of the presidential powers to be exercised only on the advice of the cabinet. India. In India, parliamentary sovereignty is subject to the Constitution of India, which includes judicial review. In effect, this means that while the parliament has rights to amend the constitution, the modifications are subject to be valid under the framework of the constitution itself. For example, any amendments which pertain to the federal nature of the constitution must be ratified by a majority of state legislatures also, and the parliament alone cannot enact the change on its own. Further, all amendments to the Constitution are also open to a judicial review. Thus, in spite of parliamentary privilege to amend the Constitution itself remains supreme. Israel. The Knesset, the legislative branch of the Israeli government, has the power to enact and repeal all laws. It enjoys de jure parliamentary supremacy, and can pass any law by a simple majority, even one that might arguably conflict with the basic laws of Israel, unless it has specific conditions for its modification. The Knesset can adopt and amend basic laws acting through its capacity as a constituent assembly. The Knesset also supervises government activities through its committees, elects the Prime Minister of Israel and approves the Cabinet of Israel, elects the President of Israel, and recommends the Controller of Israel. It also has the power to remove the President and State Controller from office, revoke the immunity of its members, and to dissolve itself and call new elections. Italy. The sovereignty of Parliament in Italy is born from parliamentary privilege, but, in one of the most comprehensive and compelling systemic judgments, the Constitutional Court had opened the justiciability of interna corporis. By the way, remnants of the old theories are expressed in autodicia, which involves subtracting the ordinary courts of all acts performed within the chambers. The choice to set off some acts of the presidents of the parliament has been criticized as an attempt to exclude them from judicial review, even when pertaining to individual rights. This has given rise to some conflicts between the judiciary and parliament, brought to the Constitutional Court, who gave useful elements to restrict the legal definition, compelling the legal doctrine through the modern evolution of the sovereignty of Parliament. New Zealand. The concept of parliamentary sovereignty in New Zealand is derived from that in the United Kingdom. The constitutional position in New Zealand is clear and unambiguous. Parliament is supreme, and the function of the courts is to interpret the law as laid down by Parliament. The courts do not have a power to consider the validity of properly enacted laws. In recent years, some legal experts such as Robin Cook in Taylor v. New Zealand Poultry Board have questioned how far parliamentary sovereignty goes. There are several laws and conventions that limit the exercise of parliamentary sovereignty. For example, the maximum term of Parliament and some other matters relating to the electoral system may only be altered by a parliamentary supermajority or by a majority in a popular referendum.